Good afternoon. Well, it's 10 minutes past 4. Let's start our session. I see that participants are still arriving, but time management is most important for us. So welcome on board to our discussion, Data Analytics in International Arbitration and Regulation of Artificial Intelligence in International Arbitration. First of all, I would like to remind that session and discussion is recorded and shall be posted on YouTube. So bear in mind that, asking questions and making remarks. Our session shall be moderated by my distinguished colleague Wojciech Sadowski from French, Polish, Hungarian law firm Queritius. Am I right in pronunciation?
Yes, you are.
Thank you. So Wojciech is a prominent dispute resolution lawyer in Central Eastern Europe and demonstrates interest in artificial intelligence and data analytics, and is a frequent speaker on this topic. So I'm very glad him to have as a co-moderator. And the second co-moderator will be me, Paulius Docka, from Primus Derling, a pan-Baltic law firm. One more organizational issue. We have small changes in our administration way. So we will see how many participants will join. You're still joining. So if we will be able, we will promote you to the panelists. If not, then the rules of the game shall be that you raise the hand before answering the question or making a remark. So probably that's it for introduction, and I will ask Wojciech to start with a freestyle introduction.
Thank you, Paulius. It's a real pleasure to be here today. We're discussing artificial intelligence as something that may come one day in the future, and we are contemplating whether we should be dealing with it at all as dispute resolution lawyers, or whether it's rather a thing that we should leave to IT specialists and IT lawyers. And as a matter of fact, the artificial intelligence is already upon us. When we are using Microsoft Office 365 suite, and we want to put together a presentation in PowerPoint, and the moment we put content on a blank page, the software is proposing a couple of potential layouts of the slide, and that's nothing else than predicting what we would want this content to look like. And that is nothing else but the very simple example of the use of artificial intelligence. And if we submit such presentation and we use it in the context of an arbitral hearing, is that the use of artificial intelligence in international arbitration? My point here is that artificial intelligence is already upon us. It will creep in with every month, every year, in any possible way. So, is there really any way we can stop this surge? Paulius, what do you think?
Oh, sorry, I was on mute. I think there's no chance to stop it. And then we have a warming up question to our colleagues. Probably, as you know, French government banned publication of statistical information about the judges, and judges' decision with 5 years imprisonment sentence potentially, and Justice Reform Act Article 33 basically is preventing anyone and is targeting legal tech companies focused on litigation and prediction and analytics from publicly revealing the pattern of judges' behavior in relation to court decision. Well, if starting with a classic literature question, who is afraid of Virginia Woolf, Wojciech? Why it's happening?
I don't know. I mean, and more importantly, I'm wondering about the long-term effect of this law. So there used to be a law in the Austrian Austro-Hungarian Empire that prohibited any technological progress, with the effect that the empire had the least developed network of railways at some time, and it did not stop the advance of technology and railway and other modern advances. So I'm really wondering whether the French law will have any other effect long-term than adversely impacting the development of French legal tech companies, and in particular, wondering whether the US or for example, Chinese legal tech companies would care about these limitations. Would that stop the development of their IT tools that are used to analyze decision-making process taken by humans? Wondering what the participants of this presentation would think about this.
Are there any opinions? Will France fail with this legislation banning data analytics? So Wojciech, we are not warm up still.
Okay.
We should go further, and before just jumping to our next session on future of data analytics and international arbitration, just bouncing back to the same question, would such a ban would be imaginable in Poland?
Would it be imaginable? Perhaps. I think, it really depends on what the parliament wants to enact at any given moment, and we have been witnessing these days that, for example, the English parliament is also up to adopting an act which would be not probably adopted in normal circumstances. So I would not rule out that Polish or another parliament would follow the French rule. The question is really whether we can avoid systemic approach to analyzing decisions taken by humans and human judges. And we also know that there are already some initiatives in the market that focus specifically on international arbitration. So, for example, there's a US startup which is called Dispute Resolution Data. They collect data from around 20 arbitral institutions and provide information covering industry type, the amount, location of the proceedings, and so on. And on that basis, they provide certain estimates to the users as to the likely duration or cost of proceedings and so forth. Paulius, do you think that the amount of information that such startups are currently able to collect is sufficient, is enough to create a reliable database, or is the net cast too narrowly?
Yeah, indeed. I'm a bit skeptical about the collection of data and about netcast. It looks like still we see that arbitration institutions tend not to publicize their awards, and lots of steps are going that direction. Mm-hmm. But still, I think that at the moment, I would not rely on such a, let's say, data analytics which has a very limited access to limited arbitration institutions. Of course, probably you might discover a kind of pattern of certain arbitrators if you have a significant amount of awards to be scrutinized by artificial intelligence. But at the moment, I'm skeptical about that. But time will show.
And do you think that institutions will be, or are, or will be willing to share such information with such startups?
I think that there will be probably a huge shift in policy, and obviously that it's not only institutions, it's the users, but the users of institutional arbitration will think about that, and that will depend on industry. If we, as the players of industry, will lean towards sharing awards and making them available to data analytical legal startups, and so that will work. And I see that we have a interest from our participants. Artem Dudko from London. Artem, you are on, but on mute.
Hi, can you hear me?
Yes, we do.
Great. Very interesting topic of conversation. On the publication of decisions by institutions, there seems to be a trend in recent years for arbitral institutions to start publishing as much as they can about such awards. In view of what you are saying now, does it not make sense instead for institutions not to publish their awards, but to actually analyze the awards themselves, and perhaps produce an offering of some sort of commercial access to the results of such analysis of the awards that have gone through their institutions? Potentially, similarly, large law firms that are involved in many arbitrations can also harvest such data from the arbitrations that they're involved in. Thanks.
Well, it's the valuable remark. I think that one of interesting questions is that institutions having a large number of arbitrations running, like ICC, they probably could do their own database and an algorithm analyzing even efficiency of arbitrators. And the interesting question probably would be if the large law firms are considering such a option, developing their own database. Maybe someone from really large law firms could comment on that. I see Miroslav Dubovsky from DLA from Prague. Maybe Miroslav, DLA is developing kind of such a tool.
Now I hope you hear me. And first of all, Paulius, thank you for putting us into the large law firms category. So perhaps, yeah, I'm very thrilled by that. And essentially, at this stage,
we lost you, Miroslav.
Miroslav.
Is it better now? Okay.
Yeah, you are back. Yes.
Okay. So what I was saying, that clearly at DLA we are having out the database of arbitration and some of the decisions, but probably not at the level you are aiming with this discussion or we are predicting to be in the future. Perhaps that's the way how we will develop in the future, but currently that was not something we were very actively looking at, and because what we have now at the firm for our internal purposes works perfectly and fine.
I have one caveat with respect to the concept of either institutions or law firms preparing such databases as a proprietary products or collections of data with the purpose of sharing them. And my concern is whether the universe of information is large enough, because what we consider to be a large number of cases in terms of international arbitration and an institution, maybe perhaps a couple of hundreds, maybe 1,000 awards per year. And in terms of big data, frankly, it's nothing or close to nothing. If we take into account that one of currently the most advanced artificial intelligence algorithm, which is called GPT-3, is using 140 billion learning parameters. And that means, I think, 410 billion tokens, which wants to say pieces of information, as the base that was used to teach the system how to predict future decisions. I'm simply wondering whether 1,000 or even 10,000 awards would be a sufficiently large database that would allow the system to make any reliable predictions, especially given that the arbitrators will vary from one case to another, the facts will vary, and so will the law. So perhaps until we have either a much broader learning base, and that would have to include also the legal acts and treatises, and also the state court decisions rendered in standardized, repeatable, factual, and legal patterns, that I'm skeptical whether such databases that would be developed privately by various law firms or institutions would be very, very useful.
We have again Artem with a question. Artem, you are on.
No, that's just a lesson to lower your hand once you've asked a question.
Okay. I have basically a question about confidentiality, and well, arbitration is always advertised as confidential, and sharing awards sounds a bit against all the basic principles of arbitration. Wojciech, what's your point on that? How it will work, or how it might work?
Do you mean, Paulius, in terms of the approach or willingness of the institutions to share awards with
Right.
these legal texts? I think it is and will remain a concern. I had a conversation a couple of days ago with the Secretary General of the leading Polish arbitration institution, who said that even though they have default consent of the parties for the publication of a sanitized award, and even if it takes an effort from the Council actually to oppose to the publication rather than seek an active consent from the client, they still encounter objections to publications of awards in most cases. So I think this is still the prevailing approach of the law firms and the parties as well. But as I said before, I think eventually it will not matter as much, because those systems will, based on artificial intelligence, will learn from law as such, and not necessarily with respect solely to arbitral decisions. So, of course, to an extent, it will be important for them how arbitrators decide on, for example, procedural issues. But with respect to the substantive decisions, I think that it shouldn't be a serious impediment.
It's interesting point you are raising, that probably even if we have access to half of arbitration awards, it's still not enough. It's still not a big data. We have to have more input to have a reliable result. Do I understand correctly that at this point?
This is my understanding, at least as things currently are. The fascinating thing about artificial intelligence systems is that they are increasingly able to learn from each time fewer parameters. So there's demonstrations which can be found in the internet. It just that those scripts now need just a couple of hints in order to understand what is expected of them, and they can predict accurate results and deliver results with a satisfactory degree of accuracy based on just a couple of leads. So maybe 2, 3, 5 years from now, those couple of hundreds awards may be sufficient.
So I turn to our attendees. Maybe there are any comments on the topic we have discussed. as if there are no, we will move to a more interesting topic. It's predictive artificial intelligence and arbitration and use by arbitrators and arbitration councils. So moving on, just again to warm up, I always I love very much the quotation by executive of Mercedes-Benz, Christoph von Hugo, who said that obviously that car makers future are autonomous cars, and autonomous cars will obviously shall be programmed in the way that to save drivers and passengers' lives, even if that means sacrificing lives of pedestrians. In situation where there are only two options. And the question is, which was raised several times, that would you travel in self-driving car programmed to minimize overall fatalities in accident if it means sacrificing its own passengers? And 70% of US respondents said no. What would be your takeaway on this issue, Wojciech?
I would prefer to be provocative and ask another question. Would you whatever decision I or you or any of the participants would make with respect to the question so posed, I would ask whether the answer would be different. So would you consider buying such a car if you know that the overall statistical occurrence of car accidents were to fall by, let's say, 20% as compared to cars using human driving. So what I want to say is that with autonomous cars, it's either or. Either the car is programmed to prioritize the safety of the passengers or the safety of the driver. But with respect, but what really matters is statistically is the overall progress that we have. And it's actually the anecdote about the car or the problem, because it's one of the fundamental problems of artificial intelligence. I can share an anecdote which relates to this. So a couple of months ago, before COVID, I was taking a flight from Frankfurt to Los Angeles, and I happened to be seated next to a very famous Polish explorer who has been to the North and South Pole a couple of times. And he told me about his new project, which was to go around the world alone, just accompanied by a humanoid robot in an autonomous car. And he was back then flying to Los Angeles to meet with a US corporation that was helping him from the technological standpoint with that project. And then he was flying to China, where people were actually building that robot for him. And then he was moving on to India, where people were supposed to train that robot for him. And he told me that the way in which he sees the future is that automation and artificial intelligence are going to change the labor market, not only by taking away the jobs that currently exist, but also by creating new jobs, such as robot trainers. And interestingly enough, we reconnected this morning through social media. And I asked him about the progress of that project of his. And he said, well, currently it's on hold because he couldn't pass the borders because of the COVID situation. And my reaction to this is actually, it's the human which is now a problem, because a humanoid robot in an autonomous car would be able, of course, to travel around the world even with COVID. So I think it's a nice way of looking into these things of autonomous cars, artificial intelligence, and the impact that this will have also on our future and future of our work as lawyers. What do you think, Paulius?
Yeah, probably. It's the worst scenario is to overestimate algorithm and artificial intelligence. Now, and to underestimate for future. I would turn to participants. The question is, we will have more specific discussion about arbitration and artificial intelligence, but maybe anyone who has a remark whether we are ready to pass critical decisions to artificial intelligence or to algorithms.
Or does any of the participants know from experience that in his or her country, the software or the artificial intelligence is already taking decisions with respect to some claims or even administrative law decisions, such as allowing or grant of benefits or anything of that kind?
Oh, Miroslav, you are on air.
Okay. Well, I just wanted to follow up on that first question actually of yours. I don't think that we are yet ready to pass the decision-making processes to the artificial intelligence, because the artificial intelligence itself is not there yet, that programmed and assembled in the way that it could really adapt unbiased decisions. And there have been recently a study, which I'm aware, which has been happening in the US, where they have been trying to program artificial intelligence to take decisions in criminal law. And clearly, what you do in that case is that you input the data from the actual cases. And what were surprising is that the IO decisions were similar, I know better than those of the real judges, because all the biases which have been in the reasonings and in the decisions of the real life judges have been progressed and programmed in the same way into the artificial intelligence. So the problem which was created by the system was just passed over to the artificial intelligence, and therefore there haven't been any dramatic improvement in the samples and the tests which they have been running.
Well, probably there is no perfect reality, and that means there's no perfect input data. And if there is no perfect input data, then of course there will be no perfect output data. But I would go back to to Wojciech comment previously that artificial intelligence learning only arbitration awards is not enough. Algorithm has to learn more. That means theories, books, and so on. And only then there will be a possibility to get a better decision. So probably, Wojciech, let's move to arbitration realities.
Okay, and just before we do this, I just wanted to briefly to comment on the last thing you said, because there is a scientific paper by the team that created GPT-3, which is that currently most advanced AI system, and you're bound to hear a lot about GPT-3 in the next months. It's such a powerful tool that the creators refrained from releasing it to the open market, especially before the US presidential elections, because that tool has so immense possibilities of generating content that will be indiscernible from the human-generated content to a normal eye. So the potential for abuse and creating of fake news is immense. And the creators of that system figured out that increasing the amount of the learning data that you feed into the system to make it learn or pre-learn does not mean that you can have every time better results depending on the amount of the information that you feed into the system, which has been so far print, or so to say, that the learning mix is composed of something called the Common Crawl, plus a good mix of books and Wikipedia. But the problem they discovered was that just as reading more books beyond a certain number doesn't make anyone smarter, so there are limits to the way in which computers can learn. And so time has come now also to teach these programs other stuff. So movies or videos or music or other sort of content that is not necessarily containing documents. And when we can achieve that, then I think we will also have better results with respect to the decisions which are rendered by these systems. And also on Miroslav's comment regarding the accuracy of decisions taken in criminal matters in the United States, this study is obviously very well known. But it also touches upon a much broader problem or a series of problems. So the question really is about the information that you feed into the system to make it learn and make decisions on that basis. So, for example, if you fed the system with all historic decisions that were taken in the past, for example, in criminal law matters, and you had a case of a shoplifter who had been caught red-handed on stealing a loaf of bread from a shop, the system could potentially say that the proper punishment for that person should be a mutilation, because that's how it was most frequently punished in the past. So this touches upon the very important issue of the ethics and the ethical filter that we need to apply to these systems. But this is something in the this is something that is still ahead of us.
Move probably to more arbitration issues.
Absolutely.
An appointment and challenging arbitrators.
Absolutely. So the question is whether the participants would consider using the tools that exist on the market or may exist based on the analytical review of decisions taken by arbitrators to appoint arbitrators. Do you think it would be allowed, or would it be useful?
I know that Ilya Nikiforov always has a good points on those issues. Ilya, maybe we could share floor. And are you ready for artificial intelligence choosing an arbitrator for you?
Well, I do think it's inevitable. I don't think the choice, as far as there is a critical human mind at the end of the chain, the use of any tool to facilitate a human decision is unethical or anything. When we speak about, well, your discussion, very interesting one, about the array of big data to feed to the artificial intelligence, whether it's big enough for to be able enable conclusions. I have a few observations. One is that a single arbitration case is not necessarily a single data point. It has probably thousands and hundreds of thousands of data tokens. Second, as far as substantive law is concerned, lives not only through arbitral decisions, but also through court decisions, which are more multiple. And coming to arbitration point, sorry, certain type of data as personalities, institutions, length of the proceedings, cost of the proceedings. These are the tokens or the data that are bespoke to arbitration as such. And I think, I don't know if it's driven by artificial intelligence, but there is a research tool on Walter's Kluwer, arbitration data research, which well, to a degree, accurately predicts the costs and length of the proceedings, depending on the type of the procedure chosen and the nature of dispute, amount in dispute. It is being used, this output, actually. I knew of some cases where the reasonableness of parties' costs was assessed again the output of the system. So that was my intervention. I don't know if I'm on the video or not, but anyway, yeah.
Well, you are on air, but not on video.
Okay. Thank you for giving me the word, Paulius.
So Wojciech, are you ready for algorithm challenging arbitrator you have appointed?
I don't know. And I also think, Paulius, that currently it's more of a hybrid system. I know of a project originating from the US, but currently based in the UK, that tries to analyze the approach of arbitrators based not only on the artificial intelligence analysis of the decisions rendered by the person, but also the psychological research done by ex-police officers who collaborate with that project. But we have a hand raised from Anthony Mel Shrink.
Mel, you are on air.
Hello, I'm calling in from Cambridge because I actually have an article coming out in Arbitration International this month on this very issue with regards to using AI to appoint arbitrators. And I guess I'd love to have your thoughts on it, because I look at it from the perspective of going back to the debate between Jan Paulsen and Brouwer about the idea about party interests, and that if we had an AI select arbitrators, I mean, others have looked at it, the concept of how innately whenever a party picks someone, there is a human bias to be in favor of that party. And the idea of having you put in characteristics that you want in an arbitrator, including qualifications, knowledge area, etc., that by having arbitrators picked by the AI, they will be free from, first of all, they'll be free from believing that they've been appointed by someone, so they'll be able to come to their own decisions without any prejudice. But also the idea how it could change arbitration credentials altogether, because we would no longer be looking at networking in terms of who you know and who's a big name, but actually looking at who knows the governing law, who is familiar with the seat, who is a good arbitrator in terms of keeping things on time, data analytics like that, so that people are picked almost more for merit than by who is well known amongst our peers.
Okay, I think it's one a very good comment. With one caveat, I'm to a degree skeptical to which extent the AI system would pick purely on the basis of the merits rather than on the basis of its own algorithm. And the question is whether, and Mel, also the question to you, whether you think that such system would promote the creation of startups on all sorts of companies that would help wannabe arbitrators to position themselves, such as the websites are being positioned from the SEO perspective in Google, so that they're more likely picked up by those systems. And the related question, to which extent those algorithms should take into account all sorts of equal representation pledges and other initiatives that are out there in order to promote more diversity in arbitral appointments.
I actually think that an AI system could actually promote diversity, because one of the leading problems currently in terms of having more diverse panels is often also the obligation to do what's best for your client. And there have been studies that show that if the other side picks a well-known arbitrator and you pick a less well-known but more diverse arbitrator, there's a concern about prestige bias affecting the president in a tripartite panel.
Right.
So one of the problems is that we often see diversity enter into arbitral appointments via the presidential appointment by institutions. But if we want to advance this further, would be the idea if you have an AI and you could put in that you would like to have it put a diverse arbitrator in, then you would have people appointed, and it wouldn't, like I said, by having them not have an allegiance, and I don't want to say that people will try to be neutral, but by not having a human select, you will have people be appointed that otherwise wouldn't because of the concerns about prestige bias. So there could be a sense where it would increase diversity amongst arbitral appointments.
By the way, I fully support Mel. I think that purely data analytic based selection of arbitrators might significantly improve the diversity. So, Wojciech, we should probably move to regulation. It's a very interesting topic, and we see that some technology organizations they do not believe that it's absolutely possible to regulate algorithm, and probably myself, I'm not a huge believer in regulating algorithm. And they think it's far beyond capabilities of any government, and the idea is to combine governmental regulation. Now we see some kind of attempts by OECD principles and UK white paper, and self-regulation by industry. And what do you think? What would be most efficient way to regulate use of artificial intelligence in international arbitration? Or maybe we should skip that problem.
I think it's a very, very complex question. I think it's very difficult to answer it in a straightforward manner, because obviously there will be national legislations which will need to be taken into account. We should probably think long-term about whether the New York Convention on Enforcement of Foreign Arbitral Awards will require an amendment or at least a favorable interpretation that would address the problem of enforceability, or to put it from the opposite side, possibility of denying enforcement to awards which are rendered with the use of artificial intelligence in the decision-making process. And of course, that will also require, as a minimum, some changes in the soft law, such as the IBA rules, because so far we are all familiar, for example, with the rule that it's possible to involve counsel in the preparation and the redaction of the witness statements of a witness. But what about the use of an artificial intelligence script that would actually draft the statement for the witness in a writing style that mimics the writing style of the witness? Should that be allowed? Should that be disclosed?
Yeah, by the way, it's you raised two very interesting questions. One about New York Convention, because it looks like for me when I'm reading the text, it refers to arbitrate a human being, and use of artificial intelligence might touch this cornerstone of arbitration, New York Convention. And referring to our attendees, what do you think about the disclosure of the use of artificial intelligence by the opposite counsel? Would you like to know if the opposing party is using algorithm artificial intelligence tools, or you think it's just irrelevant? So, Wojciech, tell our audience is thinking about that. What's your opinion? What scope of disclosure should be relevant?
With respect specifically to your question, right? So to which extent the opposite party or a party uses artificial intelligence? I don't have a clear view on this, but I think that to the extent the arbitral tribunal would be using artificial intelligence, for example, to digest any amount of information which is on the case record, that possibly should be disclosed to the parties, because it may be a salient problem a couple of years from now, because it may happen that each of the arbitrators, human arbitrators, may be assisted by a different program. And those programs may be using different learning sets. They may be using different algorithms, and those algos may be subject to different ethical and legal concerns.
Well, yeah, you're jumping to really, really tough question. But for example, if the tribunal are assisted by artificial intelligence tool which acts as a secretary, you think the disclosure is necessary, or it's again, it's up to the tribunal?
I think it's an excellent question, Paulius. I'm actually interested to hear what the attendees of this discussion think about this topic.
We should refer to Mel. Mel, maybe you could comment on that question.
In terms of how, about what the use
disclosure.
of
Disclosures on use of artificial intelligence.
Well, the problem with that, and I wonder from an academic standpoint, is how this might run afoul of counsel's obligations in various jurisdictions. Because theoretically right now, if I were to use some device, you could argue it might be work product privilege. And if you have that situation, so I don't know, there's a difference between, say, you know, right now there's a debate going on about disclosure about, say, third-party funding, but that doesn't touch on actually some thought processes of counsel. But the idea of using AI is, you could look at it whether it's an independent or whether it's a tool. And if it's a tool, you could say it would just be like same as using some proprietary analysis technique that a law firm may have, and they don't have an obligation to give that algorithm out because that's part of their work product.
What about the arbitrators?
Well, I think from an arbitrator standpoint, I agree with you on that point, that you would have to say, because ultimately, if you are taking into outside sources into your deliberations, in a sense of being fair under the model law or almost any arbitral act, you would need to have both sides have the right to comment on it. For instance, if Wojciech was acting as the arbitrator and you were using a certain form of analysis or data pool that I would find objectionable as one of the parties, I would feel I should have the right to counter it and explain why that's inappropriate. So there should be a disclosure by the arbitrators in terms of using AI, but for the counsel, you run into issues in terms of privilege, depending on the obligations of the counsel.
That's true. We're just running out of time, basically. That was very fast. We have 2 minutes, and I would ask Wojciech maybe a few words summarizing our discussion.
Thank you, Paulius, and thank you all the attendees for staying with us, and especially those who have interacted. It has been a very lively and interesting debate, and certainly the discussion about these topics is not over. I would say it hasn't really started yet, seriously. And in the years to come, I think it will be one of the most salient problems in international arbitrations. So I'm very much looking forward to seeing you at the next discussion on this topic, and I hope it will be sooner than we may anticipate.
Thank you for joining us, and I hope that next year we're able to join live discussion in Moscow. Thanks everyone. Wojciech, many thanks for your input, preparation, and interesting thoughts. And well, we started at the time, and we are just finishing 5 o'clock. And well, thanks everyone. Let's keep in touch.
Thank you, Paulius.